Good afternoon, everyone, and thank you for joining us today. We're conducting employment law live question and answer period. I'm Lluc Cerda. I'll be answering your questions today. I'm a senior associate, the managing associate of the Calgary office of Samfiru Tumarkin. So I'm very happy to be here. Feel free to put your questions in the chat. We're going to try to get through as many of them as we can today. I want to follow up on a discussion that we had at the last time I was on, was whether you should pursue your employer to get a written employment contract. So if you recall, my advice at the time was there's no need to get a written employment contract. You have plenty of rights without a contract. And really, you shouldn't chase your employer to get a written contract, because they'll oftentimes put terms in there that are detrimental to you, that take away your rights. They'll put in non-competition clauses, they'll put in termination clauses. They'll put in clauses that they can change, your working conditions and things of that nature. So this is not helpful to you, and they don't have those rights unless you sign a contract giving them those rights. So definitely be wary of asking your employer for an employment contract. That being said, there are times where you do want to have something in writing, all right? And I want to explain to you how to go about that without necessarily getting an employment contract drafted. So most often what my clients want to see written down somewhere is what their schedule is going to be. And also, since COVID, what the work from home arrangement is going to be, all right? So for instance, schedules, people might have, a set schedule Monday to Friday, 9 to 5. And, all of a sudden their employer opens up a night shift. And can they go now on night shift? Well, it depends on a few things. But of course, if you have a written contract that says your schedule is 9 to 5, Monday to Friday, you have a much stronger case that the employer can't switch you over to night shift without your consent. All right. Now, how do you go about doing that? All right. So what you need to know about a contract, it doesn't have to be, signed and witnessed and with all of that, notarized and all the complicated legalese. A contract can be a lot simpler than that. It can simply be an email exchange. Actually, there was in the news recently, I think it was a Manitoba court, found that someone simply replying with a thumbs up emoji to a text or a messenger message that they got was enough to form a contract. So really, I want to emphasize that, it doesn't have to have this formality that people sometimes think contracts have. Simple enough. If you have an agreement over email, for instance, that your schedule will be 9 to 5, right? Then that's your schedule. That's a term of your employment now. If you can do it before you start or as you're starting your job, that's ideal. And you just ask your employer, what's my schedule going to be? It's going to be Monday to Friday, 9 to 5. You take that email, you save it. If they say some Monday to Friday, 9 to 5, subject to change as required, that means that if you agree to that, then essentially they can change your contract at any time. So that's where you go back and say, well, I don't know if I want this to be subject to change. All right, please explain to me what that means, what the parameters of that are. All right. Again, same thing from work from home. We see a lot of people sold their house during the pandemic and moved further away into the country or whatnot to have more space so they could work from home, and also to just have more space for whatever the reason. It doesn't really matter. But they went from being a 30-minute commute from work to being a 2-hour commute from work. And now if they get called back to the office, they can't do that commute every day, right? It's unrealistic. So if you are being offered a work from home arrangement, just make sure you get it in writing that that's permanent. So basically, if someone offers you work from home and you just follow up. So this work from home, I'm permanently working from home from now on. Yes, there you go. That's the agreement. You have an agreement now in the eyes of the law, right? So you don't need to flesh this out with a long contract full of legalese. So I want to just emphasize that for you, that it's important to get the important things in writing, but also in a way that doesn't, have a lawyer draft up a contract that's going to take away all your rights. Okay, so there are ways to get what you need. It can be as simple as getting a thumbs up emoji in response to a text. All right, the courts have showed us that. So get that in writing. Another thing, that I think you really have to think about is bonuses. I see this sometimes. Someone will tell you verbally that you're going to get a bonus. Get that in writing. Just send them an email saying, I just want to confirm today's conversation that where you said that if I stay for an extra 6 months, I'll get a $10,000 bonus. Actually, even if they don't respond, that might be enough to prove that you guys discussed the bonus and that the reason you're staying for the extra 6 months is for the bonus. All right. So you don't even necessarily need a response. If they respond and say, whoa, we never discussed that, you completely misunderstood what I said, then you know. If they say, yes, that's what we discussed, absolutely, then you're entitled to the bonus if you stay the whole 6 months. If they don't even respond, you can say later, well, why didn't you respond to this? Why didn't you clarify this for me, right? You have a stronger leg to stand on than to go and say, well, actually, I had a verbal conversation with my boss where he said I'd get a $10,000 bonus. And he's being like, oh, I don't recall if I said that. I don't think I would have said that and all of that. You have to prove that you're entitled to a bonus. It's your obligation to prove that you are. So you want to have some beginning of proof that this was actually discussed. All right. So at least with that email, you have proof that there was a discussion. Right. And then determining what was discussed, that can be left to the lawyers to figure out and to prove or disprove. But at least you're on a stronger footing than if you didn't get anything in writing. So yes, usually you don't need a full-fledged employment contract, if you're working for someone. But yeah, if there are terms that are important to you, things like scheduling or working from home, or compensation questions, so that you can just send a quick email to get confirmation that the two of you and your employer are on the same page. So that's my 2 cents about that this week. We got our first question coming in here from Brennan. Brennan is asking, if you don't have a written contract, can your employer change your duties? How can you prove that your job is what it is without a contract? All right, that's a very interesting question, and we're going to follow up with that. So another thing you can ask is for a list of your duties. All right, so for instance, if you're being hired, I don't know, as a machine operator, then of course that doesn't mean that you're a driver and that you deliver parts, right? So you want to have a list of duties that clearly states that what you do, right? So if they say, well, okay, you're a machine operator that delivers parts now, you can say, well, listen, that's not the job I agreed to take with you. So no, I'm not delivering parts. Either you keep me on the machine or you terminate me with severance, all right? But also don't discount that just past practice is a good indication of what your terms of employment are. So for instance, if you're paid $30 an hour, you don't need a contract that says your wage will be $30 an hour. It says it right on your pay stub, right? So if they cut you down to $20 an hour, well, you have the evidence there that you were being paid 30, now they're paying you 20. That can amount to a constructive dismissal. So you don't need to have your wages $30 an hour written in a contract, right? That'll be on your pay stub. Same thing with vacation, right? Vacation, if they send you an email saying, you accrue 3 weeks of vacation per year, there you go. And then the next year they say, well, now it's 2. Well, actually that's a change, right? Because it used to be 3, and we all know it used to be 3 because I took 3 weeks off last year, right? Now, in terms of vacation, that change might not amount to a constructive dismissal. So I wouldn't necessarily quit and demand severance if they just mess with your vacation without at least calling us first, all right, to discuss what your best options are going forward. So yeah, job duties, that's a very easy ask, right? You say, like, what are my job duties? The job duties might be in the job posting as well, right? So, if you're accepting a job, save the job posting, just ask them to confirm that the duties are the ones in the job posting. There's a lot of ways to get the other side to confirm your understanding of things. And that's really what a contract is. We're both on the same page on what is happening here, all right? So it doesn't have to be completely fleshed out by a lawyer for it to be enforceable. And even if it's not enough on its own, the context might allow a judge to find that, yes, actually what your interpretation of what was happening here is the correct one. But having something in writing can be important. But like I said, avoid chasing your employer to discuss what your severance should be when you're terminated. Discussing what happens. Can you take your clients with you when you leave? You can, if there's nothing saying that you can't, then that's one of those things that you absolutely can, right? So keep that in mind. We have a question coming in from Sammy on YouTube. Sammy is asking, If I give my 2 weeks notice, I am terminated the same day. Am I owed severance at all? So generally what will happen is if you give your 2 weeks notice and they say you don't need to come in for the next 2 weeks, what you're entitled to is those 2 weeks, all right, that you would have worked otherwise. You told them I'm leaving in 2 weeks. They say you don't have to come in. That's fine. I don't have to come in, but you need to pay me those 2 weeks that I was willing to come in. All right. So that's generally how it works. Okay. So yeah. Henry is asking us here. I was assaulted at work and I was denied unemployment. I appealed unemployment and won a decision that said it was unsafe for me to return back to work. Can I sue the employer for wrongful dismissal? Okay, so I think I understand the timeline of events. So you were assaulted at work. You either took a leave or at some point you quit because you didn't want to go back to work. All right. And so EI now agrees with you that there was no obligation to go back to work because you feared for your safety, because I guess this employee was still around that had assaulted you. If it wasn't an employee, maybe it would have been a customer or someone else. In any case, yes, you may have a claim that basically because you can't return to work because it's an unsafe workplace, then you're owed severance. So a few things to consider. What happened to the aggressor here? If that aggressor is no longer in the picture, then it's harder to argue that the workplace remains unsafe. What did the employer do to contribute to this? For instance, if the employer knew that this person was unstable, knew that this person had been bullying in the past, didn't really terminate them prior, and created the environment where this assault could happen, then you have a stronger case that the employer is also at fault here, not just the aggressor. And because the employer is at fault, then the employer owes you severance. But yes, if the workplace is unsafe because there's someone there that wants to beat you up, you have no obligation to go back, and you're probably owed severance, right? Because who controls the workplace? It's the employer. If they have someone who's a bully there, then definitely you are owed severance. So Henry's adding, following up, saying that you were not provided any severance and that this aggressor is still there. So definitely something you want to talk to us a bit more so we can get the full picture here, so that we can give you some advice. Why don't you reach out to us? Any of you here wanting to reach out to one of us here at Samfiru Tumarkin, very easy to do. Just go to our website, employmentlawyer.ca. It's right there on the screen for you, employmentlawyer.ca. We'll get in touch with you very quickly, set up a time to speak to one of us, and we can go through this in more detail and let you know what your rights are, Henry. We'd be happy to help. I'm just looking through the questions here. We have an email question coming in from Madeline. Madeline is asking, my company was taken over by an American company. They want to install software to monitor staff. Are privacy policies in Canada different from the US? So I don't know if I can answer that question. I don't know what the privacy laws are in the US. What I can tell you is this: it kind of depends what province you're in, Madeline, because each province have their own privacy laws here in Canada. All right. So I work in Ontario. I work in Alberta. I also practice in Ontario, but I live and work in Alberta. In Alberta, there are privacy laws that protect employees who are working for private employers. All right. So what's a private employer? It's a non-governmental employer. So you're not a government worker or a hospital or anything like that. In Ontario, only government jobs have privacy laws. All right. So that's what you need to know about that. So here in Alberta, even non-government private sector employers are subject to privacy laws, and there are some constraints imposed by the Privacy Commissioner of Alberta. Those are very easy to access on the web, and they deal with monitoring as well. So I was looking them up recently. For instance, the monitoring can't be secret. Generally, they shouldn't include sound. So for instance, if you put a camera in a workplace, it shouldn't be turned down to have sound as well. So that would be a big no-no in terms of privacy. You have to be made aware that it's there. And generally, a camera in an office would probably be inappropriate. Camera maybe in you have to have a reason to put the camera there. So a camera in an office, a camera in a lunch area, right, would not be appropriate. If you're dealing, with clients, maybe a camera in the storefront, you see that a lot in stores to prevent theft and things like that. And you always see it when you walk into the store, smiling, you're on camera. That's there because they have to put that there. They have to flag to you that you're being taped. Okay. So it kind of depends what the monitoring is. The monitoring has gotten very sophisticated now with computer-based work. They can count keystrokes. They can just secretly turn on your camera. That is theoretically, technologically possible, but that would not be appropriate in Alberta with the privacy laws that we have. Ontario, I've said this before, I think a lot of people would agree with me. We need a privacy law for the private sector, right? So that you can have some kind of constraints to what an employer can monitor about you, collect about you, share about you. You want to have those kind of constraints in place, and we're not there yet in Ontario, and I think we need to do a bit more work on that. So that's my political piece for the day. Is you write to your PM if you're in Ontario and be like, where are we with privacy laws here? Because this is not good, right? All right. I have a question coming in here from Jan Gamfi. I think I pronounced that correctly, hopefully. Jan is asking, I have been with my employer for approximately 9 years. How much notice am I obliged to give my employer before quitting? Okay. So generally, the employment standards laws talk about how much notice you have to give. So in Alberta, for instance, you'd be at 2 weeks, I believe, 2 weeks that you'd have to give your employer. In Ontario, there's no requirement under the Employment Standards Act that you provide any notice, so you can just quit. That said, if those of you who watch the show know that I've discussed the common law. So the common law is law that's judge-made, and that's where it's your full severance entitlements refers to common law, essentially. Now, under the common law, your employer has to give you notice of termination, has to give you severance, and you have to give your employer notice of resignation. It's nowhere near as much notice as the employer has to give you in terms of severance. So it's still probably about 2 weeks. It gets to be a bit more notice, not so much on the length of time you've been there, but on the kind of job that you have. So you can imagine a CEO of a Fortune 500 company who leaves with 2 weeks notice is going to get in trouble. Okay. They're going to get sued by their boss because they didn't give enough notice. So it could be a long time, like for someone who's a CEO, right? It could be 6 months of notice that you have to give, right? But generally, what you're trying to do is give your employer a reasonable opportunity to prepare for your departure. All right, it's got to be reasonable. If it takes them 6 months to hire a replacement, and you're in an admin role, that's too much time. They're dragging their feet. So in that case, I guess my short answer is I need to know a little bit more what kind of work you do. How crucial your job is to the business, how hard it would be to replace you. But I would generally say for employees, I would say, 2 to 6 weeks, 6 weeks really on the outside. That's a long time, 6 weeks. And see what your employer says, right? If you tell your employer, listen, I'm planning on leaving in 4 weeks. I'm flexible on the departure date, but I'm planning on 4 weeks. Tell me, is that going to be sufficient for you? Generally, they don't want to keep you around, right? We saw earlier in the show, someone gave their notice of resignation. They were told to stay home, right? Because they don't want someone working there that's not committed to the workplace. So definitely just propose something, right? And be flexible with your start date at your new job, right? That's what I would say. All right, Henry's still following up. Henry is saying that the employer refused to investigate. Okay, so if they even refuse to investigate, then they're part of the problem, definitely. Another thing you can consider, Henry, is making a complaint under health and safety. All right, making a complaint that you you were victim of an assault. You made a complaint about the assault to the employer. The employer refused to investigate. They would at least have an obligation to investigate an assault. All right. So you can make a complaint to health and safety as well in your province. We do that in Alberta. We do it in Ontario. I'm pretty sure we do that in BC as well. We have a question from MP on Reddit. My mother was recently laid off from a nonprofit. They said they would pay her out her vacation days, but that was all that was provided. Is she entitled to anything after being let go from a nonprofit organization? So that's the thing to know. Like, nonprofits are not special in the eyes of the law. If you're terminated from a nonprofit on a without cause basis, you're owed the same severance than if you had been terminated from a for-profit corporation. All right. So definitely, MP, your mother is entitled to termination pay and severance pay. Yeah. So definitely, if she wants some help with that, we're happy to help. You just reach out to us. We're at employmentlawyer.ca. Employmentlawyer.ca. If your mother's in Alberta, she can speak with me. My name is Lluc Cerda. For those who are just joining, I'm the senior associate, the managing associate of the Calgary office of Samfiru Tumarkin. We're here to discuss your employment law rights today, so feel free to drop a line. We have another 10 or so minutes to go. I'm going to try to get to as many of these questions as I can before the end of the day. So that we can answer all your questions today. So you're a healthcare provider. Jan is following up. Yeah, a healthcare provider. I wouldn't give her more than 6 weeks. 6 weeks is even that is a long time. Honestly, Jan. So if you're a nurse or something like that, then yeah, I think that 2 to 4 weeks is plenty in that regard. So Jan says, thank you for answering my question. Jan, it's my pleasure. I'm here every other Monday. So if you have any questions that come up, you can come and ask me when I'm here in 2 weeks from now. Or also for any of you watching, if you're on LinkedIn, feel free to look me up on LinkedIn. My name is Lluc Cerda. And I also post on LinkedIn and I answer, questions from people that send me questions online. Lluc Cerda, it's got a special spelling, LLUC. But yeah, it makes me easy to find on LinkedIn. So look me up there. We have a question from Len Healy on YouTube. Len is asking, can an employer delay your share options if you are on maternity leave? So yes. So what you'll see happen speaking of LinkedIn, I actually posted a little bit about this last week, I think it was, and I'll be writing something for our website, for our blog about this shortly as well. So really, Len, what you need to know is when you were given your stock options, you were probably also given a stock option plan. All right. So stock option plan has all the terms and conditions of the stock option. Okay. And the stock option plan will often have some clauses in there dealing with, what happens if you're terminated, what happens if you resign, what happens if you die, what happens if you go on a medical or maternity leave. Okay. And so you have to look at that to see what it says about your specific situation, which is maternity leave. So in my experience, I've looked at a lot of these plans. They're all a little bit different. So I don't know exactly what yours says, but what I've seen generally is that, for instance, you have a bunch of shares that are going to vest, say, in October. So in October, you'll have the option to purchase 1,000 shares at $10 a share. All right. But during October, you're in the middle of your maternity leave. So what they'll say is that vesting of that option to buy those shares is going to be delayed until sometime after you come back from maternity leave. All right. So long as it's properly drafted and legally drafted, then if you agree to the stock options, then you agree to that plan. So you're kind of bound by it. Yeah. So that's what happens. So you have to wait till you get back from maternity leave, and maybe a few months after that, for that stock option to vest so that you can purchase those shares at $10 a share. They might be worth by that point, $15, $20 a share. So you sell them right back and you pocket the difference. That's the concept, right? But yeah, in my experience, I haven't seen any plans where if you're on a leave, you'll lose your stock options if you're on a leave, but it will be delayed till you come back. Yeah. We have a question from Reddit, on Reddit from RS Life. RS Life is asking, can an employer make you sign an NDA that prevents you from talking about your pay? All right. So NDAs, I think, is a really an American concept. I haven't seen a lot of NDAs here. So there are confidentiality agreements for sure, right? But I think that might be in the Canadian context what you're referring to, where basically you sign an employment contract that says, here's the confidential information you'll have access to. Here's what you can and can't do with that confidential information. And they might say, well, discussing your pay with other employees is no. You can't do that. All right. So if you sign on, theoretically, that's binding on you. Then you have to ask yourself, well, what are the consequences of that? Say you do discuss it. What can they do? Can they terminate you for cause? Can they suspend you? Can they give you a warning letter? You've obviously breached a term of your contract or the policy. What's the discipline that flows from that? All right. So in my view, I think that terminating you for cause, for discussing your pay, probably wouldn't stand up in court. All right. And then you'd have to look at the other forms of discipline that they might consider. Now, there was a point in Ontario where they were going to make changes to the law to make it illegal for employers to prevent staff from discussing their wages, right? And the point of that was to have a bit more wage transparency, so that everyone could, know what everyone else was being paid and make sure that they were getting a market rate salary. There was an election, and then that was stripped. So there's no protection from that kind of stuff in Alberta and Ontario, unfortunately. I think, if I'm going to get on my bully pulpit again, I think that those protections are overdue in employment law, standards legislation. We shouldn't be able to talk about how much we earn freely without consequence and without reprisal. I think it just makes things more transparent and makes things more equal for everyone involved. But as the law stands right now, which is what I think you're really asking me, RS Life is, those things are legal, unfortunately, and would be enforceable to a degree. Like I said, I don't think that you can be terminated for cause just for discussing your salary, even if there is a clause in your contract that says you can. All right, that's my view of it. We have time for one last question here. The question is from YouTube and comes from Jane. I was let go from my position for safety concerns. I've never had any issues or write-ups for this before, and I don't agree with their reasoning. I worked there for 7 years before this. Is there anything that I can do about this? So it's a bit light on details, Jane, I got to tell you. Safety concerns can mean a wide array of things, and safety concerns can be serious. All right. So for instance, if you're, operating heavy machinery while intoxicated, that's a safety concern, but that's quite serious, right? That can definitely lead to a for-cause termination. So we have to see what the safety concern is, what you did, what the company says the policy is. But I have successfully defended people who were terminated for safety violations of a wide variety of sorts, and basically got that for-cause termination reversed. So if you want to send us a bit more details about what your case is about, Jane, I would be happy to help. As I said, I'm on LinkedIn. You can send me a private message. My name is Lluc Cerda. Or you can reach out to us at employmentlawyers.ca. And you have the website on the screen there, and we can discuss some more at that level. Also look up Samfiru Tumarkin. They're on LinkedIn as well, also posting a lot of stuff on there that can help you out. So feel free to reach out any way you feel comfortable. We want to discuss this issue with you guys. That's why we have the show. It was great to see you all here. Some really interesting questions here. I'll be talking more about the stock options recently, so keep an eye out for our blogs, because it is an interesting area where not a lot of people know exactly what they got into when they accepted a stock option. We're back doing this show again tomorrow. My colleague Madalena is going to be on. She's on at 1 p.m. Eastern. So if I didn't get around to all your questions, save them for tomorrow. Madalena will be happy to answer all of them. All right. So thanks for joining, and I hope you have a great rest of the afternoon. Thank you. Bye now.